Okay. Thank you for everyone that's made the time to attend. And for those that weren't able to, I hope this video provides some assistance to you whenever you have the chance to watch it. So again, my name's Julie. I'm from Tenants Victoria. I'm one of the lawyers there. And tonight we're just going to be talking about some particular topics around renters' rights that are quite prevalent in our community, or some of the common issues that we're finding these days. And just before we jump into that, I just want to acknowledge that we are meeting on borrowed land. So in the spirit of reconciliation, myself and Tenants Victoria are gathered here today on traditional lands. For me, it's the land of the Wurundjeri people. For yourselves, it may be something different. And I just want to pay my respects to the elders present and emerging, and extend that respect to all the Aboriginal and Torres Strait Islander peoples that we may have with us today. And then just as a small disclaimer, lawyers love their disclaimers, but basically these slides are information only. So legal information, yes, they're not legal advice. Legal advice is generally tailoring the information to your circumstances. And so if you feel that you needed more in-depth information about a particular question or query, then definitely feel free to reach out to our services. Our contact number is here, and you can also attend our website as well that has a lot of self-help resources. But basically, if you did have any questions, please feel free to pop yourself off mute or put the question in the chat. We've got our training coordinator, Rowena, with us that's managing the chat tonight. And then so basically, we're just jumping straight into it. We're going to be going through these main 4 topics today. So starting the rental agreement, repairs, rent increases, and entry rights. So that's if rental providers or real estate agents want to attend the property. So one of the things that you're going to notice a lot with the language in the environment or in the community is basically that it's changed. It's now interchangeable, but legally, as of the 29th of March, 2021, tenants are no longer a thing. It's renters now. Landlords are also known as rental providers, and tenancy agreements are now residential rental agreements. So if you use the old terms, we're going to understand what they mean, but it's just helpful in case you see, this renter or rental provider on the on the web and kind of wonder what they are. That's basically all it is. So basically, with starting a rental agreement, there's a couple of things that you should note. The changes that we had with the regulations in March earlier this year have made some changes and added some protections in for people. So now when you're applying for a rental property, there's a couple of things that you should do before you decide to sign away and pay for the bond and all that jazz. If you need some assistance with lodging a bond or with getting money to cover the bond, there's services out there. There's the rent assistance program that provides free bond loans for people that can be moved from property to property. Just have a look. There's definitely heaps of services on the market to assist in that space. With COVID at the moment, a very prevalent thing that we're seeing is that people are being offered bids to raise the rent so then they can win the property. That's technically not allowed. So it can be reported to Consumer Affairs Victoria if you're finding that conduct is occurring. A lot of real estate agents are kind of not so much outright saying, oh, you need to bid to get your place, but it's intended. And so you could feel like you're potentially stuck playing this game when technically under Section 30F, it's actually banned and it's a punishable offence. So report it to CAV if you see it, CAV being Consumer Affairs Victoria. There's also a ban on false and misleading advertising. So that's things around, saying there's NBN connection at the property. You don't need to do anything, just plug and go, when really there's no internet there. Or if they say, there's a swimming pool at the property and because we're all in lockdown, you can't go do inspections. You sign up for the property, you move in and you find it's a bathtub in the backyard. That's misleading and false advertising. So that's also something that shouldn't be happening. With limits on information, it's basically it's basically extending your rights or your privacy basically with previous rental history. So, they can't ask if you had a claim made against your bond or whether you took your rental provider to VCAT. So those are some of the things that you're protected against now. There's also a limit on how your personal information can be used. So normally with your details, what the real estate agent or the rental provider might do is check a tenancy database, or more colloquially known as a blacklist, to see if your name is on there. If they're going to do that, they need to notify you of it. They can't just use your information however they please. It's only in the form that it was intended for. So if you're filling out an application for a rental property, they can only use the information to assess your capacity to enter into that agreement. It also comes off the back of some forms of discrimination. So if there's questions being asked about your age, your disability, employment, activity, or the industry you're working in, some of these personal characteristics, they're banned. They're not allowed to be asked. If you feel that you are being asked these questions that may be a form of discrimination, then again, it's not allowed under Section 30A, can be raised with Consumer Affairs Victoria, can also potentially be raised with VCAT if there's an issue while you're in your tenancy. So basically, it's now a protected area to make sure that this doesn't happen. So in terms of what to do before you sign, so that's before you even kind of get into the property, just check these red flags, make sure those things aren't happening. But once you get through all that, you're happy with the property, before you sign, what you should be doing is basically having a look at the main information that you should be getting from the rental provider. So one of the things that has been coming up a lot for us at Tenants Victoria is that people are getting issued notices to vacate because the rental provider decided they wanted to sell the property. It's a hot market out there at the moment. A lot of people entered their tenancies for 2-3 months and then they're getting issued with a notice. So before you sign into an agreement, ask if the rental provider is intending to sell the property. They're supposed to tell you this information anyways under Section 30D, and that's supplemented by Regulation 16. I'll talk to the law a little bit more and how to find that. But basically, it's under the Residential Tenancies Act of 1997 and the regulations that just recently came in from 2021 March. So then basically with those laws in place, the rental provider needs to give you certain information, being whether they're going to sell the property, whether they actually own the property, or whether they're subletting the property with or without authority, whether there's a mortgagee action against the property, whether there's an embedded network. So this again is something that we're finding more and more common, which is where instead of you having the flexibility to choose, a company like AGL or Energy Australia or whatever other company that you may choose, it's now a whole network that is responsible for the whole property. So this is usually more for apartment complexes or like townhouse structures and stuff like that, where the owners corporation might just get one energy company to cater to all of the properties. With that one, they have to let you know who the energy network is and their contact details and their privacy rights and all that jazz. If there's been a homicide at the property in the last 5 years, if your property meets the minimum standards, which we'll talk a little bit about a little bit later on, and whether there's any building structure issues that may result in mold or dampness in the property. And then let's have a look. The list kind of goes on. So some of the main stuff that you think you would want to know about. So, safety checks of gas and electricity, whether the property is heritage listed, whether there's been any drug trafficking or cultivation at the property, whether there's any asbestos, building plans or permits intended for the property, or any reports on building defects or safety concerns. So just the stuff that you think you should generally know, it's now written in law to say that this is the stuff you should be getting before you enter an agreement, especially the owners corporation rules. So with this one, if you have an owners corporation that's responsible for the property, you don't just have your rules and your responsibilities and duties under the Act. You also now have to comply by the rules of the owners corporation as well. Can't really do that if you're not provided with the rules. So double check With the rental provider, they'll normally tell you if there's an owner's corporation anyways. It's the rental provider's responsibility to provide you with the rules. And then let's have a look. Moving on to the next bit, which is just about the actual rental agreement itself. So with rental agreements, they're usually between two people. So the rental provider and the renter, and then it will tell you what each person's duties and responsibilities are under the agreement as well as under the Act. In terms of what form it should be in, technically it can be in verbal form. We see that quite often, but with the new law changes, they're trying to steer people away from verbal agreements to make sure that there's more concise and clear written agreements between parties. So now, depending on what kind of arrangement you have, whether you're in a normal private rental, in a share house with co-tenants, where you and your friends all live together and you're all on the lease, or whether you're in a rooming house, the rules do slightly change. If you're not sure, call us, check in, because it's vital that you get the information you need before you lock yourself into anything. And just again, in case there's any problems later on, you want to make sure that you're going to be protected or sufficiently protected, right? So basically with fixed term agreements, most of them do need to now be in writing. And there's two types of tenancy arrangements you can enter. A fixed term tenancy, which is normally 3 months, 6 months, 12 months, however long you choose, or there's the periodic month by month. Normally, what people do is they'll join on a 12-month fixed term, and then after it lapses, then they'll just let it roll over to a month by month until someone chooses to end things or choose to re-enter another agreement. With written rental agreements, you must be given a copy before you sign it. So it can't just be like, oh, we discussed this, just sign this little section here and lock yourself in. So you should be given a copy so you can review it yourself. It should give you the information that you need, similarly to what we discussed on the previous slides, as well as the more important information, where to pay your rent to, who's the owner, who's the real estate agent, what are the contact numbers for emergencies, things like that should all be in the rental agreement as well. And then basically, if you're not sure whether it's complying with the Act or whether it's scrupulous because there's some terms that have been added in there, then definitely feel free to give us a call, seek some legal advice before you sign anything. And then basically, after you sign the agreement, both parties should have a copy of it as well. So it should be provided to you within 14 days. And then we go into prohibited terms. So these are some of the scrupulous kind of terms that you'll see in some agreements, where you have to steam clean the property every week, or you have to pay, exorbitant lease breaking fees if you wanted to leave the property at, last minute notice. So there's some things that can't actually be put into an agreement now. And again, just want to remind everyone that if there's any questions about any of the slides I'm going through, probably best that we deal with them right there, right then, before I kind of move on to the next session. But let's just have a quick squiz here. So we have a quick question in here about whether working heating and cooling is to be provided. And I'm going to provide you with a very legal answer, which is it depends. I see Rowena's so kindly left a note there as to where to get some information on the minimum standards, but I can definitely go back to that and talk to it a little bit more as to why it depends. And then, so I'm just going to move on, and then we can go back and address that. I'm pretty sure Rowena will remind me in case I forget. But in terms of prohibited terms, so some of the things that can't be added in anymore is actually listed under Regulation 11. And if you go to the Act and look at Section 27B, you'll say, oh, look at the regulations. So that's all that really means. But for example, one of the things that can't be done is there can't be a rental payment method that forces you to pay fees. So there needs to be one free form of payment method, and there also needs to be a form that is available for direct debit. So if you're paying by CenterPay or you're paying by BSBN account, there needs to be an option for you to do that. They can't force you to use like a third-party app that we're seeing quite often these days as well, where you have to sign up and pay through that application, but then the disclaimer says they can use your information however you want. Technically not really allowed to do that. But again, if you have those concerns, reach out to us. We'll let you know what your options are in that position. It's also an offence for them to be in the rental agreement. So if any of the prohibited terms under Regulation 11 are in the agreement, then you can basically just either go to Consumer Affairs Victoria and report it, or you can technically argue that it's an offence to put that provision in there, so you want it removed. Or you can go to VCAT and argue that that section should actually be invalidated because it is a prohibited term that shouldn't have been added into the agreement in the first instance. So basically, general rule of thumb is a prohibited term, despite being specifically listed in Regulation 11, the gist of it is if it tries to amend or change your rights and duties under that Act, it's generally a prohibited term. So that's just for you to look out for. If you see something that kind of triggers red flags, then it's a good idea to kind of check in with us if you notice those things. And then on the next slide, let's have a look. So basically just going through the VCAT option again, if the rental provider doesn't want to remove the term in the agreement, and then there's a whole back and forth between you and the real estate agent or the rental provider where you're saying, no, you need to remove it. And they're like, no, you don't need to. Then there's the option to escalate it at VCAT essentially. So I might just go back here for a sec. And anyone...
Sorry, Julie. I just have another question in the chat. Graham was wondering, he says, we've moved to a rental property in June. One of the bedrooms doesn't have a curtain or a blind for privacy and to keep the light out. Does the landlord have to provide one? I know you might cover that along the way, but I just thought I'd flag that one as well.
Yeah, awesome. Thank you. That's most likely going to be answered in the minimum standards section. So then when we get up to that, we can have a bit of a discussion about that one as well. Can anyone see the Victorian numbered regulations page? So it says Residential Tenancies Regulations 2021, Regulation 11. Can anyone see that?
Yep.
Oh, okay, awesome. So you can see.
Yeah.
So basically, this is Regulation 11, and this is the prohibited terms. I thought I'd just quickly show you so you know what they are. So basically, another big one that is added and shouldn't be added is the term indemnifying the rental provider, basically saying you can't seek compensation from them or sue them if they do something wrong. You can put it in there, but it's really not going to be too effective, especially when we've got section 27 and 28, where we can seek for the VCAT member to invalidate or remove that section on the grounds that it's a prohibited term. So basically, like I said, rule of thumb, if it's trying to change your rights or it's adding more responsibilities onto you than what is normally necessary, generally a red flag there for a prohibited term. But again, these are just things that are specifically listed here as a prohibited term. I'll show you how to get to these regulations later. These slides, I'm pretty sure, are also being shared. So I will change my screen back so then we can continue on with the slides. There we go. Okay, so now are we back on the prohibited terms page?
Yep.
Awesome. Okay, so then moving on to the rental provider database. So this one here is, normally there's a tenancy database, also known as a blacklist for renters. This is actually one for rental providers. So flip the switch. Consumer Affairs Victoria, sometimes they do choose to prosecute offenders being rental providers for their breaches or real estate agents. And this list will tell you who has recently breached an order or offended under the Residential Tenancies Act. So you can have a bit of a squeeze there. Don't be too excited. It's not fully extensive or anything like that with heaps of people on there. But it is a starting point if you wanted to have a look. And then basically this brings us to the end of the first session. being starting a tenancy, how to enter one, how to sign a lease, what you should be looking for. These are some websites or some pages on our website that is helpful for people starting a lease. It is quite a bit to read through, but that's the law. There's always a lot of information that you'd rather know than kind of not know in hindsight. So if you have the time to read it, definitely feel free to. If you have any questions after reading it, feel free to reach out to us. But these are some of the pages that will provide you with really concise and helpful information on how to get started and making sure that you're covered from head to toe before you join a tenancy. And then basically we're going to go into repairs, and from memory, this is the section that also talks about minimum standards. So hopefully we'll be able to go through that in this session. And then, so let's see how we're running time. Okay, I think we're okay. I'll move on quickly. So with rental provider duties, one of the things that rental providers have to do is to provide the property in a good state of repair. So that's under Section 68 of the Residential Tenancies Act. And there's an addition to that that was recently added, which says that it also needs to be reasonably fit and also suitable condition for living as well. So it's not just good enough that it's in good repair, it also needs to be in a livable condition. So, you know, if they put a plastic bag up to cover a window, not really going to be sufficient. And then, so in saying that, with repairs, with breaches to not keeping the property in a good state of repair, it opens up options for repair options. So then what we can have a look at is with the next step, don't be scared to ask for repairs. We have this so often where people call and they're like, oh, I don't want to be a bother. You technically have a duty to notify the rental provider if there's something wrong with the property. So that's not to, you know, put pressure on you. That's to just basically let you feel free to tell the rental provider and the real estate agent when there is a problem. So don't feel like you're being, you know, nitpicky or anything. There's actually a duty for you to do that. And so you're just basically asking for what you're entitled to. Whether the repairs happen or not, and whether you want to enforce it is a different matter. But basically, you also have duties as well. So mainly being that you need to tell the rental provider when there's a problem, like what I was saying. And if you identify anything that needs to be broken, that's broken or identified as damaged in the condition report, but it may not be, and you need to kind of amend that report, then that can be done as well. The condition report at the beginning of your lease is actually, it's not the most crucial piece of paper in the world, but it is helpful to have an accurate report, just so when you leave the property, that report is going to be relied on as the state of the property, that the state the property was in when you first started the lease. So we want to make sure that's accurate as possible. And then what does a condition report actually look like? It actually looks like this here. So it's more extensive. You can see this is only page 5 of 50, but it essentially looks like this. It will just go through every minor detail of every single room that may be possibly in a property. So you don't have to fill out the whole thing. It might not all be applicable, but this is essentially what you'll be filling out. So the rental provider or the real estate agent will fill out their side. They'll give you the form, and then you can go put in your own comments. So if you feel that something hasn't been accurately described, then take your photos. They're very important. Save them. And then write in your comments there and return it to the rental provider. So this needs to be given to you at the beginning of your lease. If it's not, let the real estate agent or the rental provider know. And then we can help you organize one if they don't provide it to you. And then, so basically you find there's a problem. It wasn't listed in the condition report as a problem initially. So what do you do now? So basically you ask for repairs. There's one of two types of repairs that can occur: urgent and non-urgent. Urgent is defined under Section 3 of the Residential Tenancies Act. Non-urgent is anything that falls outside of that. There are some tricky ones where you kind of like, is it severe enough to constitute an urgent repair? But we'll talk about that in a second. So basically, urgent repairs are things that you would assume are pretty urgent, right? So burst water pipes, gas leaks, electrical faults, things to do with heating, cooling, with cooking, provisions of hot water, laundry. They're all essential services. And so to answer the question that we had in the chat before, so when you move into a new property, if you started your lease after the 29th of March this year, then technically it needs to have a heater and a cooler. So that's under the minimum standards. But if there's already an appliance at the property, but it's not in a good working order, then it needs to be fixed, right? So if the rental provider didn't want to fix it and they just wanted to leave it there at the property, it doesn't really work that way. If they're going to provide it to you as a service, they need to maintain it in a good state of repair as per their duty under Section 68. So if you go into the property and the heating or the cooling is not working, go under the urgent repair process and get it fixed. If there's a minimum standard that hasn't been met, then you can also issue an urgent repair notice to organise those repairs. Mold and dampness and pest infestations are now also urgent repairs. Those are the main ones that we see, but basically this list is the definition under Section 3 for urgent repairs anyways. And then if you're not sure if it's an urgent repair because it's a bit of a tricky situation, then basically what you can do is if it meets the definition of a failure or a breakdown, which is quite a low threshold to meet, then it is an urgent repair. So similarly to this example here, if you have a full, stove cooktop and one of them's broken, it's a failure or a breakdown. It's as simple as that. It doesn't need to be completely broken down. It doesn't need to be a complete failure. It just needs to be a failure or a breakdown of an appliance or a service, right? So it's very simple in terms of an oven, but there's things like, for example, what's something that kind of teeters on the line of urgent and non-urgent repairs? Say, for example, a fence, right? So a fence that is tilting forward, for example, on the boundary line isn't technically on this list as an urgent repair, but you could potentially argue that it is an urgent repair because it makes the property unsafe or not secure. So it kind of depends on the circumstances. But basically, if you're not sure, you could utilize either. But again, call us and have that assessment done. It'll give you a bit more peace of mind moving forward with the process. And then we can guide you from there, basically. So if it's a non-urgent repair, let's actually go through the urgent repair process first. So basically with the urgent repair process, there's an issue, notify the rental provider. Has it been fixed? Yes or no? If it hasn't been fixed, then you have two options. The first option is to fix it yourself up to $2,500 and then provide the rental provider with the receipt. Or if you don't want to pay for it or you don't have the capacity to pay for it at that point in time, then the next option available is to go to VCAT under Section 73 of the Residential Tenancies Act to ask the VCAT member to make a compliance order. So that's basically an order compelling the rental provider to fix the matter. So when you make an application to VCAT, it's about a $66 application fee. With urgent repairs, it will be listed in about 2 business days. So, in the meantime, like for example, heavy rains, your roof is leaking, you need to patch it up. That's fine. You're allowed to do that. You're allowed to call a plumber out or call out someone to help patch it over. That's covered under the $2,500. So even though it wasn't completely repaired, you can still try to seek those costs back. So you're entitled to reimbursement for it. So that's under Section 72. And if the rental provider doesn't pay you, then you basically go to VCAT and ask the VCAT member to make that order for compensation. So urgent repair process is pretty straightforward. Option 1, do it yourself. Option 2, go to VCAT, get the order to do it. Whatever's easier for you in your circumstances at that time. With the way that you doing it yourself works, you basically let the rental provider know they don't respond or they don't respond adequately within a reasonable amount of time for the matter that's at hand. Then you do it yourself, give the rental provider the invoice within 7 days, and then you get the payment, you're on your way. If you don't, go to VCAT, get that compensation order for the cost of the repairs. So then basically what some of the things you should be mindful of if you're going to be doing the repairs yourself. It basically means that you could potentially spend more time recovering money thereafter, if you've paid the money yourself and then the rental provider turns around and says they don't want to pay, if you are going to have to go to VCAT to get that order, then you also have to prove that the urgent repair met the definition under Section 3. You run the risk that if you don't do that, you could potentially be out of pocket because it's not classed as an urgent repair. So then you weren't entitled to seek those repairs yourself. You're technically also responsible for the contractor. So, you have to make sure that they've got their proper licenses, they're qualified for the job, they've got their own insurance and all that jazz to make sure that there's no liability on you if there's an issue with their work. It also prevents any issues of the repair if it's not an urgent repair. So then, if it's not classed as an urgent repair and then you choose to go organize it yourself, then you could be out of pocket. Whereas if you get the rental provider to do it, then you don't run that risk at all. You can also ask that your rent be redirected into a rent special account. So you actually need to go to VCAT to do that. And then that's just basically going to incentivize the rental provider to rectify the issue straight away, because then they're not going to be getting their form of income from you until that happens. And then basically you can try to seek compensation for the issue with the repair. So normally when there's a breach of not maintaining the property in a good state of repair, it also joins the fact that it's also a breach of your quiet enjoyment. So potentially you can make those claims there. And then, like you said on the previous slide, it will be listed in 2 business days at VCAT. And then the non-urgent repair process is like what I said before. Anything that's not classed under the Section 3 definition of the Act is a non-urgent repair. And the process is a little bit different. Similar kind of gist to it, but slightly different. So you tell the rental provider, that's the same. But the second thing is they have 14 days to fix it. So with the urgent repairs, there's no specific time frame, but you would assume that if it's urgent, it needs to be attended to pretty quickly. If it's attended to within 14 days, then the problem's over. If it's not, then you have a couple of different options. So your first option is to go straight to VCAT, and then the matter will be listed in about 7 days. Or the second option, which is generally the more popular option, is you can go to Consumer Affairs Victoria, ask for an independent report to be conducted under Section 74. And then what will happen is that the report will be an independent investigation into the property will be provided. And so normally they will get you to send photos or do like a video walkthrough of the house now that we're in COVID, and basically list down everything that needs to be fixed. So it's not just like there's one urgent matter that needs to be attended to. Consumer Affairs Victoria will provide a report on the whole property. So if there's many things that need to be fixed, it's probably better to go through Consumer Affairs Victoria, because the report will provide further emphasis to your claim, basically. And then once you get that report, you can go to VCAT and ask for the VCAT member to make orders to say that the rental provider needs to fix the matters that were reported on. With this option, you don't have the option, with non-urgent repairs, you don't have the option to organise your own repairs. That's strictly urgent repairs only. And then with eviction and repairs, this is also something that we see quite often when the property is either uninhabitable because it's just been completely destroyed by a natural disaster, or there's like a mold infestation that's kind of spread throughout the house insidiously without us knowing. But basically unless subject to those kind of conditions, you can't be asked to leave the property for the purposes of repairs, right? So you can't just be evicted. If the rental provider wants to evict you, they need to give you a proper notice to vacate and go through the eviction process. But it's usually only for extreme things like the property is unsafe and they can't do the works while you're there. You can't be put on a tenancy database because you went to VCAT. Future property managers, real estate agents, rental providers can't ask you whether you went to VCAT. There's no longer a no reason excuse for notices to vacate either. So they can't just now give you a notice and say, oh, I'm not telling you why you need to leave, you just need to leave. That's no longer an option available either. And it can also, notices to vacate can also be challenged if it was given to a renter because they asked for repairs. So that's more if you feel that there was a retaliatory nature to the issuing of the notice to vacate, or you feel like, there was an ulterior motive to it, then it can be challenged. But again, speak to one of the lawyers so we can kind of further assess the merits of that matter. And then so basically what a retaliatory eviction could potentially look like is Ali asked the oven to be fixed. 3 weeks later, he received a fixed term notice to vacate. Fixed term notice to vacate basically just meaning that at the end of his lease, or the end of his fixed term period, a notice to vacate can be issued to evict them from the property, or start the eviction process, I should say. Ali can then apply to VCAT to challenge the validity of the notice to vacate, and then they'll decide whether there's any merits to that argument or not. And then we get up to the popular topic of the night, the minimum standards. So with this one, we get a lot of calls about this as well. People are always asking whether it applies to them or not. And the answer is basically it depends. So in the Residential Tenancies Act, it does tell you what's a transitional section and what's not. Minimum standards are one of those transitional things, one of those transitional sections. So basically it means that if you renewed or you started your lease after the 29th of March, minimum standards apply. Anything before the 29th of March, minimum standards don't apply. So basically it just means that now from the day that you start the tenancy, or the day that your lease is basically renewed during that new period, the property needs to meet the standards, the minimum standards, in order to comply with the rental agreement and the Residential Tenancies Act. And so if it doesn't, then what we said on the other page, you can go seek urgent repairs for it. Or if you haven't moved into the property yet, under Section 91L, especially now when people can't do in-person inspections, you might not actually notice issues until you move in, or until you get the keys and inspect the property yourself so you can organize your moving in. Then basically you can end your agreement if the property doesn't comply with the minimum standards. So basically, what are the minimum standards? So some of the ones that are now in the Act include sufficient lighting, or artificial lighting, rubbish bins and recycling bins, which you'd think that would be there, but not always. Fixed heaters in living rooms. So when we say living room, we mean the main living area of the house. And so it's not just enough that there's a portable little gas heater, therefore it needs to actually be fixed. And then keys need to be provided on doors that can't have deadlocks on them. Ventilation meets requirements. So this is more to do with mold issues in bathrooms, or, in mildewy areas of the house. There needs to be good ventilation. The property needs to be structurally sound and weatherproof. So, is the roof leaking when there's heavy rains? You also need to be provided with a laundry, and you also need to be provided with a bathroom, wash basin, shower, and a bath. The toilet needs to be working. Cooktop and food preparation areas with a sink needs to be provided. A stove top needs to be provided with at least 2 burners. Ovens need to be in good working order. Hot and cold water needs to be able to be supplied to the bathroom, kitchen, sink, and laundry. Windows that can be open must be able to stay open and must be able to be locked with a latch at the very minimum. And there shouldn't be any mold or dampness due to building structure, which mold and dampness gets a lot of people, because it could either be self-inflicted, being like, there was an action that resulted in the mold and dampness, and then there's mold and dampness because of structural issues. So structural issues are more like in roof cornices, when it rains heavily and it kind of starts leaking through the roof, and then it kind of just sits there and in the sediment and kind of just starts building mold in the corner, compared to you not turning on the bathroom fan because it's too cold in winter. So it's mold and dampness can be a bit of a tricky one. And I should note that the people that have organized mold reports, they can be quite costly. So just be careful of that. So those are the minimum standards. But to basically go back and have a look at the question we had about curtains. So technically, curtains and blinds should be provided for at the property. if it was there previously. But that one's a bit of a tricky one because there's no specific part of the Act that says curtains and blinds need to be provided. But there's an argument that could potentially be made that it's a breach of quiet enjoyment because it's encroaching on your privacy. So probably give us a call with that one so we can give you your options. Probably not something I can do in a couple of seconds, but I would argue that curtain and blinds are required to be completed by rental providers. Just depends how. Yeah, thanks, Rowena. You're like my little Jiminy Cricket on my little shoulder today. And then we had another question about required to do after leaving the property. Agreement started in August 2019. Okay, that one's probably something that should be discussed with us in private as well. Probably need a bit more clarification on what it means, what your question is with that one. And then let's have a look. It's really hard to give direct legal advice in a setting like this, especially when it can encroach on your own privacy rights and stuff like that. But definitely, please don't be dissuaded from calling us. We're so happy when renters reach out to us and ask questions. But I'm going to quickly breeze through this next question because this is also something that's been quite prevalent. So we'll go through rent increases, and then the last bit is about entry rights and what happens if the rental provider wants to enter the property. So we'll quickly try to get through those. With the type of agreements that you have, similar to what I said earlier on, you're either going to have a fixed term agreement or a periodic month-by-month agreement. And then it depends on, the rent increase depends on what kind of agreement you're in. So if you're in a periodic agreement, then technically, yes, you're allowed to get a rent increase notice, but it can only occur once every 12 months. Whereas if you're in a fixed term agreement, you can only have your rent increased if it is specifically stated in an agreement to say that rent increases are allowed at certain intervals, and it's a calculation is provided as to the method of the rent increase. So some say 2% increase in accordance with the inflation prices. I forgot what the acronym is for that. But basically, if it's not in your rental agreement, you can't add it in. Oh yeah, let's just Rowena messaging in the chat function. So that's if you're in a fixed term agreement. If it's not in your agreement, then if you get a notice of intention to increase your rent, you can basically ignore it because it can't occur unless it's in the agreement previously and it's been discussed. Otherwise, they have to wait until the end of your fixed term agreement to raise that rent. In terms of your rental agreement, with rent increases, you don't have to agree to them. So what happens if you don't agree to it at the beginning of your lease? You can ask for it to be removed. So again, you can potentially argue that it's excessive or it's not fair, or you can negotiate to have it in a form that you're comfortable with. I know it's not very helpful when it's quite a competitive market, but again, give us a call if that happens so we can give you some legal jargon that you might be able to use to go into negotiations. And then basically, I kind of covered this already, but with periodic leases, rent can be increased technically once every 6 months, but Consumer Affairs Victoria says that it should only be increased once every 12 months. And then it shouldn't be more than once every 12 months. Otherwise, you can apply to have it challenged. And so what it means to challenge it is you can go to Consumer Affairs Victoria, ask for an independent report to see whether the amount being increased is fair or fair market value. And then if it's not for whatever reason, then you can go to VCAT and ask for that rent increase to be invalidated because it's potentially excessive. Excessive being excessive because they've increased it one too many times or because the cost itself is quite high. With fixed term agreements, they're technically once every 6 months as well. But like I was saying before, it should usually only be done at the end of a fixed term period. And you're probably wondering why why is it allowed once every 6 months if you normally go into a 12-month agreement? Well, basically, if you're in a 12-month agreement, they're not allowed to increase the rent unless it's in the agreement as previously discussed. But some people join fixed term periods on 3 months or 6 months. So that's why that's there. But if you're in a 12-month, you're pretty safe for that entire 12 months. In terms of the proposed rent increase, it should be in a proper form. You should get 60 days notice prior to it coming into effect. It should tell you how the rent was calculated, the increase was calculated, and it must also include information on how to go to Consumer Affairs or access that independent investigation. So basically, it needs one notice can be provided for each rent increase. So it can't just be like a blanket or for the next 5 years, this form's going to be in effect. That's not how it works. And then basically, if they don't use the proper form or they don't meet these requirements, then basically you can just say, no, it's invalid. Like you can't enforce it. Tough luck. Otherwise, if you want to be proactive about it, you can go to VCAT. And then that's the link for the form if you wanted to have a look at what form it is. And then basically, if you are going to challenge it, you should challenge it as soon as you get the notice of rent increase. You have 30 days to start the application with Consumer Affairs Victoria. And then after you get that report, you have 30 days to start it with VCAT. If you miss out on the 30-day notice, you can still technically potentially go to VCAT, but you'll need to seek leave from the VCAT member to do so. And usually they'll only allow it if there is a very good reason as to why you couldn't comply with the time limits. So basically what Consumer Affairs will look at when they're doing the inspection or when they're doing the assessment for excessiveness, they're going to look at the state of the property, location it's in, whether there's facilities or services that have been removed or added to add to the value of the property. Fair market value is another really big one that they'll look at. So those are some of the things that Consumer Affairs will consider when they're looking at whether the rent increase is fair or not. And then basically go to VCAT under section 45, 46 to do that. Sorry, 45 is to get the inspection done by Consumer Affairs. 46 says that you can apply to VCAT with the report provided by Consumer Affairs. And then basically VCAT can either agree that the rent is excessive. They can also set a period up to 12 months in which then the rental provider is not allowed to increase the rent thereafter as well. So that's their powers under section 47 of the Act. So then that's basically rent increases there. Again, I apologize for having to breeze through it, but I'd rather you know the information and seek clarification on it than to not know it at all and wonder, and just kind of deal with the rent increase if it comes along. And then the last bit we have is entry. So this can be for a number of reasons. This can be for inspections. This can be tradespeople attending the property to fix, things that you've requested. This can be for sale inspections or end of lease inspections. But basically at any point in time, if the rental provider or the real estate agent or an authorized party thereof wants to enter the property, they need to do so in accordance with the law. So you're entitled to quiet enjoyment of the property. Just because it's owned by someone else doesn't mean that you don't have rights there. And so if your rights are breached, basically if your quiet enjoyment is breached, there's options for you to get respite because of it. If it's because someone wants to enter the property, then if they don't comply with their requirements under the Act, then technically you can argue you don't need to let them in. If they comply with the full section of the Act, then you do need to let them into the property. So there's a duty for you to do that. But basically, if they don't enter your property on the valid grounds with the proper notice, all that jazz, it's technically an offence. You can apply to VCAT to get a restraining order stopping them from entering the property. I know sometimes they'll just rock up at your house and, demand to be let in or strong arm you to let them in. But if you know that they're going to come a couple of days later, or they've given you a time that they're going to come and they haven't complied with the Act, then you'll have time to apply for an urgent restraining order. Once you lodge it at VCAT, it takes about 2 business days to get to be heard, but you can call and try to get it expedited if it's more urgent than that. And so basically we have a look at why the rental provider can enter a property. So in terms of them entering, they need to do so in a proper manner. They need to give you proper notice. They need to enter during a reasonable time, being 8 a.m. to 6 p.m., not including public holidays. And then they need to give you the proper notice for it. So depending on the reason why they enter, there's going to be a different notice period. So it can range from 24 hours to 7 days. So if you're not sure, our website does list all the reasons why they can enter and all the time requirements that they're supposed to notify you prior to entering. And then we have a nice list here as well of what some of those reasons are. So again, I kind of listed them off at the beginning. So, you know, if they're going to show a prospective renter or a buyer through the property, then that's with 48 hours notice. If they're going to be taking pictures of advertising for the sale campaign or for the new rental campaign, then that's 7 days they need to give you notice. On the form or in the notice, they should also be listing the section that they're relying on as well. And these are some of the other reasons why they can enter the property. So if they just want to enter for the purposes of entering just to have a look, well, that would technically be a general inspection, and they're only allowed to do that once every 6 months, and they need to give you 7 days notice prior to doing that. So if one of the reasons they want to enter isn't here on this list, then it's not something that is required under the Act for you to let them in for. So if they want to enter because they left, you know, a left shoe in your laundry room cupboard and they wanted to go in and get it, you can agree for them to do that. If you don't agree for them to do that, then there's not really much they can do because it's not an allowed reason under the Act. And then so basically when they're entering, they do also need to make sure that they enter in a reasonable manner and they can't stay for longer than what's necessary to achieve the purpose of the entry. So, you know, if it's for the sake of inspections, you wouldn't expect them to be there for 2-3 hours, whereas a tradesperson might be there for a little bit longer to complete the work. And when we talk about a reasonable manner, we talk about, you know, in accordance with COVID safety requirements as they're quite prevalent in our society these days, or, you know, if they're going to be entering for the purposes of doing trades repairs, they're not going to bring a whole camera crew through your property to organize those repairs, unless you're on the block or one of those other shows. That's a little bit different. But basically, it does need to be reasonable, and reasonable is quite subjective, you know, especially if you have someone in the household that has that's immunocompromised and requires different health checks and safety checks before entering the property. You could potentially argue it's not reasonable on that ground. Whether that's successful or not is going to ultimately be up to a VCAT member to decide if the other party doesn't agree. But reasonableness, just to kind of show you the scope of it, is actually quite, it's quite subjective. And then basically, if you've been given proper notice, then they're allowed into the property, and you kind of have to let them in. If it's at a time that doesn't suit you, you can negotiate it, but there's no hard and fast rule saying that the rental provider must yield to your schedule or anything like that. Both parties kind of need to come to the table and figure that out. And then basically with sales inspections, the new law says that both parties kind of need to come to an agreement on the days for the inspections. And then with advertising, there's certain things with advertising that are allowed and aren't allowed. So, you know, in terms of photos, if they're going to send out a photographer to do that, a suitable time needs to be arranged between the parties as well. But with some of the privacy concerns, we'll cover that in this section now. So what happens if your property is being sold, or if there's rental inspections at the end of your lease, then basically what the Act says now is that it's reasonable for the real estate agent or the rental provider to conduct inspections twice a week, and they can't last for more than an hour. Of course, that changes with COVID restrictions and all that jazz as well, but that's just the basis of what should be normal in this space. And so with people that are experiencing family violence or personal violence and they have protection orders or intervention orders, they can require that inspections be by appointment only, and not just for an open inspection where anyone can kind of walk through the property. So you can arrange for those protections to be put in place for yourself. If it gets to a point where it's absolute no, you don't want anyone in, have a chat to us. We can have a look at some of the options available to you. In terms of sale inspections, with these ones, it's a little bit different now because a notice of intention to sell needs to be provided to you. So that's under Section 86. And then basically what that means is that if the rental provider wants to do an inspection at the property for a sale, they need to provide you with that notice of intention to sell 14 days prior to the first inspection. And then you're also entitled to compensation for that as well now. And then basically, if you're given a notice of intention to sell, but you haven't been given a notice to vacate yet, you can technically leave the property with a notice of intention to vacate, which is basically you providing the rental provider with a notice saying, I'm going to leave with 14 days notice because you issued me with a notice of intention to sell, not really wanting to sit here and see how things pan out. I'm happy to just go find another property and leave so I don't have to deal with it. You're allowed to do that. And then basically with compensation, if there is a sales inspection, you're entitled to either half your daily rent per inspection or $30, whichever is the higher of the two. And then that's under Section 86 of the Act and is again enforceable by VCAT if the rental provider doesn't pay that. And then we kind of get onto the photos and videos for advertising and what that means for you if you're concerned about having your goods displayed online and whatnot. So basically, if the rental provider does meet their requirements, they're entering for a proper reason, all that jazz, then they're allowed to enter for the purposes of taking photos. You do have the right to object, but only in certain circumstances. So you can object if the photos will directly identify you or someone else in the property that's living with you, if it reveals sensitive information about where you or someone else is living, whether if it shows valuable items or would increase the risk of theft at your property, or if it's unreasonable to expect you to remove or conceal such an item. Again, there's different rules for people that are currently experiencing family violence or have personal violence orders. They can ask that photos not be taken at all. And then basically, if you object, you can provide it. You should do so in writing. And then after you object to the photos being taken, the rental provider or the agent must not take or produce photos of the item, and they must not use your any photos or videos to advertise the property. And if the rental provider or the agent do use them, then again, we can have a look at restraining orders and stuff like that. So you usually are supposed to have the option to review the photos that are going to be used online. And then you can give written consent to authorize those photos to be distributed. And basically photos that are 12 years old or more can't be utilized without first obtaining written consent, especially if you are still in the property and those are pictures of your goods. And then with videos for the purposes of advertising, then basically with those ones, you must also, or the real estate agent or rental provider must also get written consent from you as well. And then so these are some of the photos and advertising materials that you need to, this is the process in which it needs to go through for the photos and videos to be used. Basically just going through what we discussed, but in a mind map, so it's a bit easier to review. So basically, if someone wants to enter for the purposes of taking photos, they need to give you 7 days notice. They need to make reasonable attempts to find a time that works well for you. If you object, then you can do so in writing on one of those grounds below there. If there's a, you may either choose to permit entry with or without you being present, up to you. And then you must not take or produce, the rental provider or real estate agent must not produce those images or videos that may be permissible. And then basically if you provide a written objection, then those photos and pictures can't be used, or it can be reviewed. You can review them before you choose to object to them. And then those photos can't be published, videos can't be published online without consent. So basically that goes through what happens with entry requirements, general sale entry, inspections for end of lease. So there is a little bit more to it. Again, everyone's circumstance is going to be different. Reach out to us if you have any questions, whether it applies to you or not. This is just a very, very general scope of what some of the law says. It's in no way comprehensive. I wish it was, so you can, go out there and advocate for yourself, but unfortunately that's not how the law works. These are our details. If you do want to reach out to us, we have an advice line, so you don't need to book an appointment and then speak to us. You can just call straight through to the advice line. Granted, it is a bit congested at times, but with some perseverance, you will get through to us. And if anyone in this chat is a social worker or part of the community, is a community worker, then there is a dedicated line for those inquiries as well. And then I see there's 2 chats in here. Okay, just admin stuff. And so I hope that was enjoyable for you. I know it's a bit hard to enjoy a lecture, an hour-long lecture, but I hope it was informative at the very least. I'm just trying to, actually, we still have anyone with us. If I can, just utilize this time really quick to show you how to get to the law. So I find this really helpful. If I can change my screen. Okay. Can I do this? Yes, I can. Okay, so the easiest way to get to the law that I was talking about tonight is to Google it. It sounds very simple, but that's what I do. I Google it. So if you go to Google and type in Residential Tenancies Act 1997, then it'll pop up here. And what I usually utilize is Ostley, so this second website here. And then it will take you to the page where I was at before, and you can basically scroll through and read all the different areas of law that I discussed today. So if we click into this one, section 65, then it is there for you. You can have a read of it. Might not be the most interesting thing, but it's just helpful to know where to find the law. And then it's the same thing with the Residential Tenancies Regulations, but instead of Residential Tenancies Act, type in regulations instead. And then basically it will look like this. So similar to the other one, and you can have a look at the law there. And then there's also our website. So you can go and have a look at our advice tab, which will cover a lot of the main themes that we see in our clinic. Otherwise, if there's a specific thing you want to search for, I always utilize the search function. It's a lot easier. And then basically with compensation, for example, just click that. If it's compensation for renters or if you're defending one, just depending on what's happening for you. The really good thing with our website is that it's very clearly set out into different tabs, but at the bottom of the page, there's also related pages as well. So it's basically going to send you on a rabbit hole search based on what you're looking at, and it's going to basically give you all the information you need to know. So that's pretty much all I wanted to go through, just to kind of give you the tools to go search it up yourself. Again, feel free to research it. If you have questions, reach out to us. But I think I've gone over time, so I'm going to leave it there. Does anyone have any questions? Now I have some people saying thank you, which I just want to say thank you guys for giving me your time tonight. And then that's it. I'm just going to see if anyone has anything else. I'm happy to hang around, but I think that's it. I think I've lost everyone. I've scared everyone away at this point. Okay. Awesome. If no one else has any questions.
Oh, I think that's it from what I can see from the chat.
Yeah. We've got some good questions in there tonight.
Yes.
And then, yeah, I think we can stop the sharing now. And is the recording stopped?
I'll stop the recording.
No, it's still going. Yeah.
Okay, might stop. And then that's it. Thanks for your time tonight, guys.